This is the next portion of our CIV Pro review. We discussed step 1, we need personal jurisdiction. We satisfy the statutory basis. We satisfy due process, and we satisfy the reasonableness reasonableness standard. We talked about subject matter jurisdiction, federal question, diversity, and supplemental. Next up, removal, venue, transfer of venue, and the Erie Doctrine. Okay, so federal question jurisdiction, diversity jurisdiction, and supplemental jurisdiction. Next up is removal jurisdiction. Who can remove? Only defendants. Only to federal court. Only if the case could have originally been filed in federal court. Based on what? That's right, diversity or federal question. The federal court has to have subject matter jurisdiction over all the claims, or you cannot remove the case. So, federal subject matter jurisdiction, federal question, diversity, and of course, if you're bringing any supplemental claims, over all the claims. When can the defendant remove? Well, at the earliest, 30 days, within 30 days from when the grounds become apparent, but no later than 1 year of filing. So how does this work? 30 days to a year. Why? It's because multiple defendants restarts the clock. It's 30 days of service of the last defendant. Later service on later defendants restarts the clock. So, but the clock ends at 1 year of filing. Where can defendants remove? Only to the district court that embraces the state court where the case was filed. Okay, quick quiz. Who can remove? That's right, only defendants. Where can they remove? Only from state to federal. If the case could have been filed in federal court in the first place. The federal court must have, that's right, subject matter jurisdiction over all the claims, or that's right, you can't remove the case. When can the defendant remove? 30 days from when the grounds become apparent. And the clock ends at 1 year, 1 year deadline for removal. Why? Because multiple defendants restart the clock. Later service on later defendants gives the later defendants the right to remove. Okay, where do we remove? Only to the district court that embraces the state court where the case was filed. And what's the last thing we need from all those defendants? Can some of them agree to remove and some of them not? No, they all must agree or join in the notice of removal. You can't leave some of them out. They all have to agree. Okay. What happens if we have some claims that are federal and some claims that are state? Well, there are some claims that the federal court might be able to hear on supplemental jurisdiction, but some claims the court might, that's right, sever and remand the non-federal question claims. Remember, that is their discretion. Supplemental jurisdiction, always discretionary. Okay, what about our home state defendant rule? What's the number one thing we need? It has to be diversity. Diversity, diversity. The defendant, home state defendant, can't remove diversity claims. If any defendant is a citizen of the forum, the defendant can't remove. Home state defendant rule, only what types of claims? That's right, diversity. Any defendant is a citizen of the forum, Going to court on diversity, home state defendant rule, can't remove. So diversity has to exist. This may seem obvious, but diversity has to exist when the case was filed. If you don't have diversity when the case was filed, how can you have diversity to remove? So diversity also has to exist when the defendant files the notice of removal. You went to court based on diversity. You had diversity when the case was filed. Home state defendant, going to court based on diversity. Guess what? Can't remove. Okay, let's talk about remand. Who moves to remand? Plaintiffs. And when do they move to remand? If the case was improperly removed. Okay, if it's for lack of subject matter, when can they move to remand? That's right, anytime, never waived. Okay, moving on to venue. Now remember, venue is one of the 12B defenses that if you don't object, you've waived it. So if you don't object in your pre-answer motion and an answer, guess what? You just waived venue. You're going to litigate in that venue. But let's talk about our three-prong defendant rule for venue. Venue is proper where any defendant resides, if they all reside in the same state, or two, where a substantial portion of the events or property giving rise to the claim occurred, or three, fallback venue. What's fallback venue? Wherever the defendant is subject to PJ. Okay, prong one, venue is proper where? That's right, any defendant resides, if they all reside in the same state. Or two, that's right, where a substantial portion of the events or property giving rise to the claim occurred. Or three, fallback venue, wherever the defendant is subject to PJ. Okay, so we have one defendant. Well, that's pretty easy. We remove to the district that the defendant resides in. But what if we have multiple defendants in multiple districts? You can remove to any district in which at least one defendant resides. Okay, that is very easy. 1D, we remove to where that D resides, that district. Multiple Ds, we get to go to any district in which at least one defendant resides. They just all have to reside in the same state. Okay, very special situations. Corporate plaintiffs, we remove to their principal place of business, not their headquarters. Why? Think about the number of Delaware corporations there are. Corporate plaintiffs, principal place of business. That is the removal venue. Non-resident aliens. Non-resident aliens, it's a free-for-all. The venue can be any district. Okay, let's go through our three-prong. Venue is proper where any defendant resides, if they all reside in the same state, or two, that's right, where a substantial portion of the events or property giving rise to the claim occurred, or fallback. That's right, wherever the defendant is subject to PJ. Corporate plaintiffs, where's their venue? That's right, their principal place of business. Non-resident aliens, venues proper at any district. Multiple defendants, remove to any district in which at least one defendant resides, as long as they all reside in the same state. Okay, now let's talk about transfer of venue. The transferor court, if you're going to transfer, you're going to transfer because, for many reasons, but the transfer court at minimum must be a proper venue. What's a proper venue? One with PJ over the defendant. And remember that forum selection clauses under our choice of law rules are usually enforceable. Okay, so when we transfer for proper venue, the law, we're going to go over that in choice of law. Okay, when we transfer for proper venue is one that has PJ over the defendant, and the court has a three-prong standard. The court may transfer for the convenience of the parties, two, in the interests of justice, or 3, by agreement. Part 1, convenience of the parties. 2, the court may transfer in the, that's right, interests of justice, or the court may transfer by 3, agreement of everyone. Okay, convenience. What does that mean? Well, it could have been filed there in the first place. Interests of justice. If it's filed in an improper venue, the interests of justice are served to transfer it where it could have been filed originally or dismiss it for forum nonconvenience. Or 3, agreement of all the parties, or where all the defendants are subject to PJ. Okay, when we move to transfer venue, what's the plaintiff's interest? The defendant has to offer a venue that can hear the case and provide a remedy to the plaintiff. That's our, quote, adequate alternative inquiry test. Is there an adequate alternative? The defendant has to offer an alternative venue which can hear the case and provide a remedy to the plaintiff. If you can't provide a remedy to the plaintiff, is that a proper venue? No. Okay, venue. We're going to go through our 3-prong analysis. Venue is proper where any defendant resides, if they all reside in the same state, or, that's right, where a substantial portion of the events giving rise to the claim occurred, or 3, fallback venue, where the defendant is subject to PJ. Non-resident aliens, sue them anywhere. Multiple defendants, any district in which at least one defendant resides, as long as they're all in the same state. Okay, the court may transfer 3 prongs for the 1, convenience of the parties, 2, interests of justice, or 3, by agreement. What's convenience? Convenience of the parties could have been filed there in the first place. And interests of justice, if it's filed in an improper venue, justice is served by transferring it where it could have been filed originally, or dismissed for forum nonconvenience, or by agreement of all the parties. And what's our adequate alternative inquiry test? That's right, the defendant has to offer an alternative venue which can provide a remedy to the plaintiff. Speaking of forum nonconvenience, let's talk about it. That's a dismissal without prejudice to file in a more appropriate court, a foreign jurisdiction. That could be Missouri, if you are in Illinois, or it could be a foreign country. The location of witnesses, the evidence, the records, a more appropriate choice of law, hardship to the defendant, availability of adequate alternative forums for the plaintiff. But the main thing about forum nonconvenience is a dismissal without prejudice to file in a more appropriate court. Okay, our last topic of this video is the Erie Doctrine. When does the Erie Doctrine apply? Only in diversity cases. Does the Erie Doctrine apply in federal cases? No. Does the Erie Doctrine apply to supplemental jurisdiction? No. When does the Erie Doctrine apply? When a federal court is sitting in diversity, it applies the substantive law of the state in which it sits, including its choice of law rules, and federal procedure. Here is our statement of fact, our rule statement on the Erie Doctrine. When a federal court is sitting in diversity, it applies the substantive law of the state in which it sits, including its choice of law rules, and federal procedure. Okay, procedure. Okay, remember there are some things that are arguably substantive or arguably procedural. Statute of limitations is one of those issues. Some jurisdictions consider it substantive, some consider it procedural. The main thing to remember is that in federal court, the federal rules always govern. Federal rules of civil procedure always govern. State substantive law will govern unless there is no federal statute that is valid and controlling, no constitutional issue, or federal treaty. Okay, this makes sense. we're going to apply state substantive law unless federal law or the Constitution or a treaty trumps via the Supremacy Clause. Okay, how do we know whether an issue is substantive or procedural? That's our outcome determinative test. Okay, would applying the law essentially determine the outcome of the case? What's the court going to do? It's going to look at the federal and the state interest. Is there a super strong federal interest, as in foreign relations or currency? Then we're going to apply federal common law. But if the state law interest is stronger, we're going to apply the state law to avoid inequitable administration of laws. When we're talking about multiple states, we get into choice of law problems. Okay, Erie Doctrine. What's our sentence? A federal court sitting in diversity applies the substantive law of the state in which it sits, including its choice of law rules and federal procedure. State substantive law. If there's no valid and controlling federal statute, constitutional issue, or treaty that would rule via the Supremacy Clause, we're going to apply state substantive law. What if we just can't decide whether an issue is substantive or procedural? We ask, well, would it be outcome determinative? If it would be outcome determinative, then we're going to look at federal law. Is there a strong federal interest? But nothing on point, no statute, no constitutional, no treaty. We just have a really strong federal interest. We'll apply federal common law. If the law would be outcome determinative, we want to avoid inequitable administration of laws, we're going to apply state laws. So generally, we apply state law unless the federal law trumps it, or either one would be outcome determinative. In the case of a strong federal interest, as in foreign relations, then we apply federal common law. All right, that's it for now. Next up, pretrial remedies.